They left my son on the front steps of his own house with 2 garbage bags and a car seat. His wife had changed the locks while he was at work. My daughter-in-law had taken my granddaughter, cleaned out the joint account, and filed a restraining order based on things that never happened. When my son called me, he could barely get the words out. He kept saying, "Mom, I don't know what to do. I don't know what to do. I don't know what to do." I told him to sit tight. Don't touch anything. Don't call her. I'm coming. What my daughter-in-law didn't know, what her family didn't know, was that the house my son was standing outside of, the one she'd just locked him out of, sat on land that belonged to me. And the property management company that handled her family's rental portfolio across 3 provinces? I'd been a silent partner in the parent company for 11 years. They had no idea who they were dealing with. They were about to find out. I want to be clear about something before I go further. I'm 67 years old. I built my life the hard way, one decision at a time, starting when my husband left me with a 6-year-old boy and a mortgage I could barely cover on a legal assistant salary. I didn't inherit anything. I didn't have connections. I had a notepad, a calculator, and the understanding that if I didn't figure things out myself, nobody was going to figure them out for me. I spent 30 years in real estate law, then 30 more building a small property management company into something that operates in 4 provinces. I did it quietly. I don't drive a fancy car. I don't wear expensive jewelry. Most people who meet me at the grocery store would guess I'm a retired school secretary. That's fine. I've never needed anyone to know what I have. I've only ever needed to know it myself. My son is 41. His name is Daniel. He's a structural engineer, a good man, the kind who actually shows up when someone needs help moving, who calls me every Sunday without being asked. He met his wife at a work conference in Calgary 8 years ago. She was charming, quick with a laugh, came from a well-off family in Kelowna. I liked her at first. I told myself the things that bothered me were small. The way she'd talk over Daniel in front of people, the way she'd roll her eyes just slightly when his friends told stories. Small things. I kept my mouth shut. Their daughter, my granddaughter, just turned 4. She has Daniel's eyes and her mother's stubbornness. I love her more than I can explain. So when my son called me that Tuesday evening in March, voice cracked, sitting on his own front steps with 2 garbage bags in the snow, I didn't panic. I didn't rush. I got in my car, drove the 40 minutes from Oakville to their house in Hamilton, and I sat beside him on those steps in the cold while he told me everything. She'd been planning it for weeks. The restraining order was filed that morning, citing a pattern of emotional abuse, things he'd supposedly said, dates, incidents, none of it true. The joint account, $43,000 they'd saved together, was gone. She'd moved it 3 days earlier into a personal account. She had a lawyer. She had a plan. Daniel looked at me with this expression I recognized from when he was a boy, and something was genuinely beyond him. "Mom, what do I do?" I took a breath. Then I said, "You're coming to stay with me, and then I'm going to take care of this." He started to say something about handling it himself, about not wanting me involved. I looked at him. "Get in the car, Daniel." We drove back to Oakville. He didn't speak for most of it. My granddaughter wasn't with him. She was with her mother at her parents' place in Kelowna, and that fact was sitting in my chest like a stone. When we got home, I made him tea, made sure he ate something, and once he went to bed, I went to my office and sat down at my desk. The file on my daughter-in-law's family had been sitting in my bottom drawer for 6 years. I want to explain that, because it sounds calculated, and it was, but not the way you might think. When Daniel told me he was serious about this woman, I did what I always do before committing to anything. I looked into it, not obsessively. I hired a researcher I'd used before for due diligence on property deals, spent 2 weeks, read the report. Her father, Lloyd, ran a family property management company called Hartley Group out of Kelowna. It was successful on the surface. The report flagged a few things. A civil dispute settled quietly in 2015, a former business partner who'd signed an NDA, some unusual corporate restructuring. Nothing criminal. Nothing I could point to directly. But enough that I kept the file, and enough that when I'd quietly expanded my own portfolio into the Okanagan in 2018, I made sure to invest in the parent company that held Hartley Group's operating licenses. Through 2 intermediary corporations, I now held a 12% stake in the licensing entity that Hartley Group depended on to manage properties across BC, Alberta, and Saskatchewan. They had no idea. I sat at my desk and opened the file again. Then I made a phone call to my lawyer, a woman named Catherine Marsh, who had been with me for 22 years and who did not ask unnecessary questions. "Catherine, I need you in my office tomorrow morning. We have a situation." She didn't hesitate. 8 o'clock, she said. "I'll bring coffee." The next morning, Catherine sat across from me with a legal pad. She already knew the basics. I gave her the details: the fabricated restraining order, the drained account, the custody situation, the false affidavit. She wrote without stopping. Then she looked up. "How quickly do you want to move?" "I want to move carefully," I said, "but I want to move now." She nodded. "First, we file to contest the restraining order. Daniel needs to be on record immediately. Second, we subpoena the bank records. She moved money 3 days before filing. That's a pattern. Judges notice patterns. Third," she looked at me, "the custody piece. Your granddaughter is in BC with the other grandparents. We need to flag that. Cross-provincial custody has specific procedures under the Children's Law Reform Act. We get ahead of it today." I let her talk. Then I told her about Hartley Group, about my stake in the licensing entity, about what I could and couldn't do with it legally. Catherine didn't blink. "You didn't do anything wrong," she said. "You made a legitimate investment. That you happen to be in a position to act on your legal rights as a stakeholder is not your problem." "I know," I said. She smiled slightly. "I just wanted to make sure you knew." That afternoon, I asked my assistant to pull the corporate records for Hartley Group's last 3 fiscal years. She had them on my desk by 4 o'clock. I put on my reading glasses and started going through the numbers. What I found over the next 2 days wasn't surprising, but it was thorough. Hartley Group had been quietly inflating management fees charged to a provincial housing initiative, a nonprofit program that subsidized affordable rental housing in smaller BC communities. The overcharges weren't enormous on a per-unit basis, but across 240 units over 4 years, they added up to just over $600,000. Fees billed for services not rendered, maintenance costs charged without receipts, inspection fees documented with no corresponding records. It wasn't my money. It was money that should have gone to housing low-income families. That's what made it so clean. I wasn't going after them personally. I was about to report a fraud that had nothing to do with my son's marriage and everything to do with public money being stolen. I called my contact at the BC Financial Services Authority on a Thursday morning. I'd worked with them before on a compliance matter with one of my own properties. I knew who to call. I told them what I had. Sent the documentation that afternoon. They told me to expect a call from their enforcement division within 48 hours. On Friday morning, my daughter-in-law called Daniel. He was sitting at my kitchen table. I was in the next room. He put it on speaker without her knowing. Her voice was controlled. Professional, almost. She said she wanted to discuss a parenting schedule. Said she wasn't trying to be difficult. Said she knew things had been emotional and maybe they could find a way to resolve it outside of court. Daniel looked at me through the doorway. I shook my head once. He told her his lawyer would be in contact. She said something about how this didn't need to get complicated. He said he appreciated that and ended the call. She called again 4 hours later. This time she asked if he'd spoken to me. Said his mother had been making inquiries. Said some of her father's business contacts had been contacted by a regulatory body and she didn't know what that was about. But if anyone had been meddling in her family's affairs, Daniel told her, again, that his lawyer would be in contact. The BC Financial Services Authority moved faster than I expected. Within 10 days, Hartley Group received a formal notice of investigation. Their operating licenses were flagged pending review, which meant they couldn't take on new property management contracts and had to disclose the investigation to existing clients. For a company whose revenue depended on that licensing, it was the beginning of a serious problem. I didn't tell Daniel any of this. He had enough to manage. The family court hearing on the restraining order was scheduled for early April. Catherine had been building a detailed record: Daniel's phone logs, emails, witness statements from friends and colleagues who could speak to his character, a forensic accounting summary showing the account transfer. The restraining order had been filed with an affidavit full of specific incidents, dates, things Daniel had allegedly said. Catherine cross-referenced every single one against his documented whereabouts. 7 of the 9 incidents couldn't have happened when and where his wife claimed. 2 weeks before the hearing, Catherine received a call from my daughter-in-law's lawyer. They wanted to talk about terms. I sat in on that call. They proposed withdrawing the restraining order in exchange for a negotiated separation agreement, primary custody with the mother, generous visitation for Daniel. They presented it as a goodwill gesture. Catherine said she'd take it back to her client. After the call, Catherine looked at me over her reading glasses. "They're scared." "I know," I said. "They know the affidavit won't hold. Likely know the account transfer looks bad. And if Hartley Group's situation gets worse, her family is going to need every resource they have for their own legal problems." "What do you want to do?" Catherine asked. "I want my granddaughter to have her father," I said. "So if they drop the restraining order, we negotiate. But I want shared custody, not visitation. I want Daniel's name on everything, and I want that account money returned." Catherine made a note. "Anything else? The Hartley situation continues. That has nothing to do with us." She nodded. Of course. It was around this time that something else came to light. My son's researcher, the same woman I used for due diligence, who I'd asked to look into the marriage separation timeline more carefully, found something I hadn't expected. There was a man in Kelowna. He'd been seeing my daughter-in-law since the previous October. She'd met him through her father's business network. He was a contractor, someone Hartley Group had used on renovation projects. The relationship appeared to have begun several months before my daughter-in-law filed the restraining order. I sat with that information for a full day before I decided what to do with it. Daniel didn't know. The question was whether to tell him and how. Not because I wanted to use it as ammunition, but because I knew once the separation was legally underway, it would surface anyway. Better he hear it from me than from a filing. I sat down with him at the kitchen table on a Sunday evening. He had a cup of coffee. I had tea. I told him directly, the way I always tell him things. He went very quiet. He stared at his cup for a long time. Then he said, "How long have you known?" "A few days," I said. "I wanted to be sure before I told you." He nodded. "Okay," he said. "I wanted to be sure before I told you." He nodded. "Okay," he said. "Okay." He didn't fall apart. He sat there for a few more minutes. Then he said, "Can we get my daughter back? That's all I care about." "That's all I care about, Mom." That's when I understood what this had always been about for him. Not the money, not the betrayal, just his daughter. I reached across the table and squeezed his hand. "We're going to get her back," I said. The negotiation that followed took 3 weeks. My daughter-in-law's lawyer, once they understood how comprehensively Catherine had documented the false affidavit, became significantly more cooperative. The restraining order was withdrawn. The account money, all $43,000, was returned. Shared custody was agreed to, with a detailed parenting plan that gave Daniel his daughter every other week and all significant holidays on alternating years. The day Daniel drove to the airport to pick up his daughter, I sat in my car in the parking lot and waited. I didn't go inside. That moment belonged to him. He sent me a photo. She was asleep against his shoulder in the back seat, her coat still on, one shoe half off. He'd written, "She asked for Grandma before she fell asleep." I kept that photo. The Hartley Group investigation concluded the following spring. The BC Financial Services Authority, working with the Canada Revenue Agency, found the overcharging scheme exactly as I documented it, and then some. The total fraud amount was recalculated at just over $800,000. Lloyd, my daughter-in-law's father, received a personal fine, a 5-year ban from holding a directorship in any provincially licensed entity, and was required to repay the defrauded amount in full. The company itself had its licenses suspended for 18 months. By the time they were reinstated, 3 of their major contracts had moved to other management firms. I never spoke publicly about any of it. I never spoke to Lloyd or to my daughter-in-law about what I knew or what I'd done. There was nothing to say. The one conversation that stayed with me happened about 6 months after the custody agreement was signed. My daughter-in-law called me directly. I was surprised she did. We hadn't spoken since before the separation. She was quiet for a moment. Then she said, "I know you had something to do with what happened to my father's company." I didn't say anything. She said, "I just want to know why." I thought about that for a moment. Then I said, "I reported a fraud that was harming low-income families. I did it because it was the right thing to do. Whatever you believe about my reasons, that part is true. The harm was real and it needed to be stopped." She was quiet again for a long time. Then she said something I didn't expect. She said, "Daniel's a good father." I know that. I always knew that. I said, "I know you did." She hung up. I sat at my desk for a while. I didn't feel triumphant. I felt tired, in the way you feel tired when something difficult is finally finished and you can see clearly again. My granddaughter spent Christmas with us that year, the first Christmas she'd had here in 2 years. She arrived on the 23rd with a backpack full of coloring books and a very firm opinion about what should go on top of the tree. She wanted a polar bear. Not a star, not an angel. A polar bear, because she explained to me very seriously, polar bears live in Canada and they are very important. I found a small plush polar bear at the craft store and hot glued a wire hanger to it. It went on top of the tree. She stood back and looked at it for a long time. Then she said, "Grandma, that's perfect. That's what I fought for. Not the money, not the licenses, not the proof that I'd outmaneuvered anyone. I fought for that little girl standing in my living room in her reindeer socks, pointing at a polar bear on top of a Christmas tree and telling me it was perfect. I want to say something to anyone who is sitting with what I've been through, or something close to it. I've had women reach out to me, daughters of friends, younger women I've met through professional circles, who are watching someone they love get slowly taken apart by a person who plans it carefully and does it quietly. And they ask me what to do. They're afraid if they step in, they'll make it worse. They're afraid they'll push the person they love away. They're afraid they don't have the tools, the money, the knowledge. Here's what I tell them. You don't have to have what I have to protect your family. You have to pay attention. You have to ask questions. You have to document what you see, dates, conversations, patterns, and you have to find people who know more than you do and ask them for help. You have to be willing to be uncomfortable before things get worse, and you have to be patient. Real protection isn't fast. It isn't a dramatic speech or a single moment. It's preparation and timing and knowing when to move. The people who hurt the ones we love are counting on us to be too emotional, too slow, or too afraid to act clearly. They are counting on love making us weak. But love is not weakness. Love is the reason you do the hard thing when it would be easier not to. Love is the reason you sit at your desk at 2 a.m. reading corporate filings. Love is the reason you show up on a cold set of steps in Hamilton in March and tell your son to get in the car. I am 67 years old. I have built something. I have protected it. And I am not finished. If this story reached you today, I want you to know it wasn't an accident. You were meant to hear it. Pay attention to the people around you. Ask the questions that feel too hard. And don't ever let anyone tell you that stepping in to protect your family is meddling. It isn't meddling. It's love in action. Please like this video and subscribe if this is your first time here. Drop a comment and tell me where you're watching from. And if someone in your life needs to hear a story like this one, share it with them. You might be exactly the person they needed today. People ask me sometimes if I regret any of it, if I think I went too far. I sit with that question honestly because I think it deserves an honest answer. I don't regret a single thing I did, but I want to be clear about why, because the reason matters more than the outcome. I didn't set out to destroy anyone. I didn't lie. I didn't fabricate. I didn't manufacture a single piece of what came to light. Lloyd had been overcharging a housing program meant to help low-income families for 4 years before I ever reported it. That harm existed whether or not my son had ever met his daughter. I just happened to be the person who finally looked closely enough to see it and who understood what I was looking at. That's the part people miss when they hear a story like mine. They think the point is that I was smart or powerful or that I planned everything out. But the real point is simpler than that. The point is that dishonest people leave trails. Every time. They have to, because dishonesty requires maintenance. You have to keep adjusting, keep covering, keep adding new layers over the old ones. And all of that maintenance creates records, patterns, evidence that someone careful and patient will eventually find. Lloyd's family built their position on a version of themselves that wasn't true. They presented one face to the world and ran something different underneath. For a long time, that worked. It works for a lot of people for a long time, but it is not stable. It never is. I didn't bring their house down. It was already built on ground that couldn't hold it. My daughter-in-law made choices that came from fear and, I think, from watching her father operate a certain way for so long that it started to look normal. I'm not excusing what she did to Daniel. The false affidavit was a serious thing, a genuinely harmful thing, and she knew it when she signed it. But I also think about the fact that she called me months later and said what she said, that Daniel was a good father, that she always knew it. There was something honest in that call, something that cost her something to say. I respect that, even now. Daniel spent a year rebuilding his footing, slowly. He's not someone who bounces back loudly. He does it quietly, the way he does most things. He got his daughter back, and he got to work being her father again. That's what he put his energy into. And watching him do it was one of the more quietly moving things I've seen in my 67 years. My granddaughter is 5 now. She is confident and bossy and extremely particular about breakfast. She still has opinions about holiday decorations that I consider non-negotiable. I consider that a great sign. What I want to leave with you is this. Resilience isn't something you find in a crisis. It's something you build in the ordinary days before the crisis arrives. Every time you pay attention to something that feels off, every time you ask a question when it would be easier to stay quiet, every time you document something that doesn't sit right, every time you make a decision based on what's true rather than what's comfortable, you're building it. You're making yourself harder to knock over. Integrity works the same way. It's not a single dramatic moment where you choose right over wrong. It's 1,000 small choices over years until the right choice becomes the one that feels most natural. The morning I sat at my desk reading those corporate filings at 2 in the morning, I wasn't being heroic. I was doing what I've always done. Paying attention, asking what's actually here, not what I want to be here. That habit didn't come from nowhere. It came from 30 years of showing up to hard things and not looking away. That's all I have to offer. Show up. Pay attention. Build something worth protecting. And when the people you love need you, be ready.